and welcome. It's good to see an excellent turnout for this meeting of the extraordinary meeting of the local planning panel. This is my first meeting as chair. I was recently appointed by the Minister of Planning for the next 3 years. My name is Stephen Lehman. By way of background, I'm an architect and town planner by training. I declare this extraordinary meeting of the Wingecarribee Local Planning Panel of the 5th of July open at 2:03 p.m. As I said, my name is Stephen Lehman. I'll be chairing this meeting. Sitting with me are expert members Judy Clark and John McFadden, and community member Richard Colley. Wingecarribee Shire Council acknowledges the Gundungurra and Dharawal people as the traditional custodians of this land we now call the Wingecarribee Shire. I pay my respects to elders past, present and emerging. I'd like to extend that respect to all Aboriginal and Torres Strait Islander persons present here today. Now, before we go any further, could I please ask everybody to turn off their mobile phones or turn them to silent. We have no apologies for this meeting, and no member of the panel has declared a conflict of interest in any of the items on the agenda. All panel members have read the business paper, received a briefing from council staff and familiarised themselves with the properties, the subject of the reports today, either by physical site inspections or by other means, including visual aids. We have in fact visited the sites this morning and conferred on them prior to this meeting. So the panel is charged, rather unusually I should say, in considering the adoption of the draft Bowral Town Centre Master Plan, the endorsement of the Engagement Outcomes Report and the Supporting Evidence Report. That's item 5.1. Item 5.2 is the adoption of the draft revised low density residential development controls review and endorsement of the compliance checklist and development application submission checklist. Item 5.3 is advice for the draft voluntary planning agreement policy to proceed to public exhibition. As well as those items, we will be determining the development applications at items 6.1 and 6.2 on the agenda. That is a childcare centre at 22 Rosemary Crescent, Bowral, and a commercial development at 51 Renwick Drive, Mittagong, respectively. So there are a number of registered speakers today. The time limit for each speaker is 3 minutes. The panel members may have questions for you after that 3 minutes. Please note that once you've made your presentation and answered any questions from the panel, that you will not be given further opportunity to speak at this meeting. In order to conduct this meeting in a orderly and timely fashion, that has to be the case, I'm afraid. But if there are important things to be found out, we will ask questions. I would ask that all speakers be heard in silence and that courtesy and respect be observed throughout the meeting. I'm sure there won't be a problem. Following the conclusion of the public meeting, the panel will move into closed session to deliberate and will announce its advice in public, which will be webcast, and the minutes will be posted on the council's website by the close of business on the following Tuesday. With that, we can commence the meeting, and the first item, 5.1, Draft Bowral Town Centre Master Plan. I have one speaker on my list, Barry Anstey. Can you come forward, please? Is there a place for the speaker? Yep. Now, sir, can you tell me, for the record, your name and address?
My name is Barry Anstey. I reside at 48 Sir Charles Moses Lane, Woodlands, and my family own properties at 24 Wingecarribee Street, Bowral, and 267 Bongbong Street, Bowral. I have a degree in architecture from the University of New South Wales in 1972. I've operated in property development since that time. This master plan, in my opinion, is fundamentally flawed. It makes no provision about car parking in terms of a Section 94 plan. We purchased 267 Bongbong Street in about 2010, I think, and the business needed to expand, and we couldn't expand it because any increase we needed to provide car parking, and there was no Section 94 or room on site to provide that. We then subsequently, to expand the business, purchased 28 Wingecarribee Street, which was a bigger property, but no car parking on site. I've attended most of the public meetings that have been held on this master plan. I've raised this issue about the no Section 94. I raised it with the administrator before the current car parks were constructed, and he said we were entitled to have a Section 94 plan. The problem is that council went ahead with those car parks, did not create a Section 94 plan before, and my view is that legally they're not able to charge for those car parks in a Section 94 plan for retrospective works done. So now they're trying to insist that there be voluntary planning agreements. And that's just trying to fix the problem that they created. Now, the situation we've got is in front of 28 Wingecarribee Street. There's a proposal to close part of the road, or not close it, make it one way. The one-way suggestion is an appropriate response because people at the moment have to do a three-point turn to get round. So changing it to one way is an excellent suggestion. But in doing that, you actually create more road space where we could have angle parking and create more parking. And I think that's what should be done. I've suggested it at these public meetings, but that's not been taken on board. Further down Wingecarribee Street towards where the courthouse is, the old courthouse, they're looking at taking car parking out, which I think is unnecessary. The other thing is the courthouse has been purchased, I think, about 12 years ago, has not been occupied, is for sale, is not proceeding because there's no Section 94 plan, because, you know, you just can't develop it or use it. Now, you know, what should be happening is, you know, we've also lost all the commercial space. There was dedicated land, part of the railway that was going to be, and in the Station Street bypass that was dedicated as public road, lost as commercial space owned by council. Where the car parks have been erected down Station Street, that's taken away potential commercial space. The commercial town of Bowral is limited in its ability to expand. So it needs to be able to have opportunities to go up. If you want to provide car parking, then you work out a bonus system where if you put together a number of blocks, you get a bonus FSR, and then people will be able to, with the additional size, work out a car parking layout that can fit under that. This plan is basically just a landscape plan. It's quite amateurish. It's not looking at the results of where we need to go. I think that's, you know, basically where it is. I mean, it's made a major effect on our business as to what we've had to invest to stay in the Shire. Thank you, sir. Look, the low density development control plan or controls that doesn't provide any provisions about seniors housing. I've written a letter to strategic outcomes, but haven't had a response. And it also doesn't cover about service departments, which are both permissible uses in the R2 zone. But what you've got to appreciate is that in the R2 zone, they are permissible pursuant to the LEP, not pursuant to the SEP, because they the SEP doesn't allow seniors housing in the catchment area, and most of Bowral is in the catchment area. Now these things are in the existing LEP and in the existing DCP, but there seems to be no comment on those things whatsoever, which is not fostering where we are. The other thing that's a concern is that the majority of what I'd say are development suitable blocks that are sort of 20 metres by 100 metres in this shire tend to be around 2,050 square metres. The minimum lot size under the 1989 plan was 600 square metres. The minimum lot size in most of the areas under the 2010 LEP is 700 square metres. So you get this position where you're sort of short of area to be able to get 3 out of 2,000 odd square metres. There is a provision under the dual occupancy that you can put a dual occupancy on 1,200 square metres and Torrens title them. So what's happening is that people are doing that, but it's just frustrating the time in what it takes to do, because you ultimately get 3 houses on the block, but you're frustrated in the way you've got to go about it. And so red tape is just constraining us. So that needs to be addressed in what's going on. The provisions about seniors housing needs to be addressed because these things are permissible and they're not covered by this review. Yeah, well, the minimum lot size that's been put into the LEP in this council for a dual occupancy is 1,200 square metres, and they will allow you to Torrens title it at that size. So if you've got a 2,000 square metre block that doesn't get you to 3 700 square metre blocks, then what you do is you cut off a 700 square metre block, you leave a residue of 1,300, you then put in a DA for a dual lock, Torrens title it and cut it into two 600s. That just seems to me to be a waste of red tape. We're going to ultimately get there, and this review should resolve those issues, particularly when in 1989 600 square metre blocks were permissible.
Okay, thank you. I think that's from me. Any questions from the panel?
Mr. Anstey, thank you. Some valid points there. I'd just like to ask you in relation to the seniors housing provisions that you mentioned there. Specifically, you'd be aware that to the extent of any inconsistency, a SEP will prevail. So, given that the housing SEP and other sets exist for seniors housing, what specific provisions were you looking for seniors housing within this policy?
Well, the position that I see is that the seniors housing SEP doesn't apply in Wingecarribee because it's prohibited in the in the catchment area. So we've just completed 9 seniors housings in Kangaloo Road. There was an issue that came up about requirements of access and disabled access and things like that, and you then get down that under the current code of council, it's not reflecting the SEP requirements, it's actually reflecting the adaptable housing requirements. And I think that's a preferable position than where it is because the SEP provisions have become quite draconian. And it's a matter of where you see these things headed. But at the moment, in the draft that I've read for the review, there's no mention of seniors housing whatsoever. Now, as I say, I wrote a letter, I haven't had a response. My reading of the new adoption of the housing SEP is that the provision of restriction of seniors housing in catchment areas still applies.
Thank you very much, Mr. Anstey. So we now move on to the third item Item 5.3, the draft voluntary planning agreements policy. I have David Dixon in favour of the recommendation is on my list. Is David Dixon here? Come forward, please, sir. And tell us about your address or your interest in this matter, if you don't.
You
You
said I was in favour.
Yeah, that's what I've got.
I'm in
Is that-
favour
Of the recommendation?
of the recommendation and against it. I believe there's a few things that need adjustment.
Right,
Um,
okay.
I am
Irrespective
local. I am
of
local.
what
Sorry,
you have to say.
Mr. Chairman.
Yep.
David Dixon, I'm a chartered engineer, specialist in civil, geotechnical, structural, mechanical and hydraulics fields.
Mhm.
And for all of the racing super yachts competing around the world, I've been involved in analysing and certifying the keels, the most important part of their structure. And as a consequence of that, protecting the lives of the crews, including myself. I know most of the panel are planners and lawyers. We think differently. That's why we've chosen different fields. Nonetheless, our views are no less important and bring perspectives that may not have been thought of or considered relevant. I deal in numbers, facts, testing, certified performance, not opinions, estimates, spin or futurism. Why is this even relevant? Well, firstly, I'd like to applaud Council for thinking of their VPA policy. However, in order to get the best result for the community, you first need to define the problems that are presented by major developments. For each of the individual site cases, understand the numbers, do the tests and certify the performance. As a part of this process, Council must ensure that the unintended consequences of the development are not borne by the community, but its proponents. In high-performance engineering, where tolerances are fine, monitoring of performance and adjustments are often necessary to ensure the safe and positive outcome. This should be the same for Council's VPA policy. It is my opinion that the proposed policy is currently flawed and that Section 8 should be amended. VPAs must encompass the proposed development's consequences for the community and not just the initial capital costs, whether they are obvious at the instigation or become apparent as the development progresses. Just as I consider the consequences of a keel falling off in Bass Strait or halfway to Fastnet Rock in the Atlantic or Mid-Pacific in a Transpac race. To include reasoning in Section 8 to allow significant development in the face of no agreement is like telling the 24 other crew members that if the keel I certified could fall off in the storm, it shouldn't be a reason to deny the vessel entry into the race, even though there is a good chance one of them could be lost. This goes not only to those consequences within the development, but where they may affect others in the community. It goes to the consequences of surrounding, supporting, or existing infrastructure, the environment and ecology, along with the ongoing costs of maintenance, or worse, repair of the damage done. Lastly, it must have a way to monitor and adjust those costs as they become obvious to those blinded by the glossy brochures or slick public lectures at the beginning of the development. For these reasons, whilst I support the Council's efforts to put a policy in place for VPAs, the policy as currently proposed needs work to make it fit for purpose and should be amended to better serve the community as a whole. Thank you.
Thank you, Mr. Dixon. Are there any questions from the panel or comments?
Just one. Mr. Dixon, thank you. You are aware that this is for the exhibition of the policy so that comments can be received by Council in order to improve it along the lines that you've suggested.
I am aware of that,
Yep.
and one of the reasons I'm getting in early
Thank you.
is
Yep.
that you might adjust it before you put it out there.
Well, this is, just to clarify, so it's about exhibiting the policy so that it can be refined prior to its adoption. So this isn't about its adoption.
Yeah.
It's a stage, but I think some of the points that you've raised will be taken on board during that exhibition period. Thank you.
Thanks.
Just before you go, I'd encourage you to make those points, in a written submission to the council when the public exhibition period occurs. Those sort of things are the things that we're seeking to hear about from the public, and that we'll be taking into consideration, council will be taking into consideration in the finalisation of the policy. So this is, what we're about today is starting the process. The real gains in the process will come from the submissions we get during the public notification period. Thank you. Do I have against the recommendation, Bob Morgan?
Yes, my name is, but before that, Chairman and members and any elders, past and present, and with us today. My name is Bob Morgan, and I am of Erridge Park Road in Burradoo. I am opposed to the voluntary planning agreement. My questions are to the council. Why would the council enter into voluntary agreements that would put ratepayers at risk of the bill when a landholder receives the windfall profits and the ratepayers receive all the costs or the ongoing costs of developing? And one of these can be seen in Renwick, where Renwick was developed and the council had to pick up the cost of putting in the lights on the Hume Highway for the entrance into the development. In 2021, there was a VPA for Sutherland Park, and that included water and included sewer. And if you're going to have these things, then they should include such things as smart technologies for environmental performance, smart infrastructure, installation opportunities, public open space embellishment and dedication, new shared pathways for longer term potential, completing the Bowral Town Loop, trees and street furniture, all riparian corridors should be in. Water quality improvements and stormwater management devices, anything for that would service that existing land, restoration and protection of heritage items and imperative information, road design to include provisions for new bus routes and bus stops, improvements to local road network and streetscape. These things should be factored in, and also land set aside for services such as fire station, police, ambulance, medical and schools, junior and senior. These things should all be factored in into any of these agreements and not left for the ratepayers to pick up the bill once somebody receives a windfall from a voluntary planning agreement because the land has been rezoned. So that's my argument, Mr. Chairman.
Thank you. Panel, are there any questions or comments for this speaker?
Thank you, Mr. Chairman. Mr. Morgan, thank you. So generally with any, well, first and foremost, this is a voluntary planning agreement policy.
So I can't hear you
It's a
very well.
voluntary planning agreement policy, so it's not actually a VPA that we're discussing at the moment. My question to you is in relation to your concerns regarding cost. I mean, generally with any voluntary planning agreement, as you will be aware, or I'm asking if you are aware, it's the important thing is that none of the parties that are part of the agreement enter under duress. So the policy doesn't necessarily put it out there that council is bound to enter into a VPA. I just wanted to ask if you were aware that There is no requirement for parties to enter into a VPA. No party can enter into a VPA under duress whatsoever, and that includes council.
But well, I'm saying, why would a council enter in if it's not going to receive a benefit on behalf of the ratepayer?
Well, ideally, council wouldn't. And I think in answer to some of the concerns that you've raised, which I think are valid concerns, and this is part of the reason why we have these discussions, VPAs generally capture public amenities and services that would otherwise be subject to a contribution, and often what they do allow is for a community benefit for those public amenities and services to be provided up front. What is captured and what is costed and what is timed is often in the detail. But I think what I just wanted to clarify there is that you're aware that there's actually no obligation, there's nothing binding on any party to actually enter into that VPA. It's actually it's very much a voluntary thing.
Well, tell that to the people who live along the riverbank who were asked to enter into a VPA so that a pass could be put up the river and returned to public ownership, and the ones that didn't agree have now had a planning certificate applied over their properties, all in fact a caveat.
Well, those types of details do need to be sorted out, and naturally VPAs are notified as part of that process. But I just wanted to make sure that that was clear, that there's actually nothing binding on any party to actually enter into the agreement, and I think it goes without saying that there needs to be a community benefit.
Well, I think there must be a minimum for the council before they can enter into these things. So I don't think they should be able to enter into them on just a whim or without consultation to the community on these things.
Thank you for your comments.
Surprised to hear that an agreement's been made that obligates people who weren't voluntarily part of it.
Sorry, I can't hear.
I'm saying, I'm surprised to hear that an agreement was made that obligated people who weren't voluntarily part of it. It's a voluntary planning agreement, so I don't understand quite how the circumstance that you've described comes about. I might ask
Dennis
Killish
to answer the question.
to
Yes.
explain the situation there. I'd be interested to know. Mr.
All right.
Killish.
Thank you.
Mr. Killish, can you do that?
Thank you, Chair. I find myself making a lot of clarifications at local planning panels and council meetings. The reference made to the riverfront land acquisitions along the Wingecarribee River, those were due diligence work as well as potential riverfront strategic land acquisitions, not VPAs. So again, I realise the New South Wales planning system is complex and infrastructure mechanisms are complex. However, we're conflating different mechanisms and different issues. The item that was referred to came up in the June council meeting. It's a long-standing policy from 2008 to strategically acquire land along the Wingecarribee riverfront to realise a long-term vision for a bicycle pathway, a shared pathway along the Wingecarribee River. That's from 2008. And some of the riverfront land acquisitions were first earmarked in 1978. So those areas opposite Briars, where some of those residential developments that are going on at the moment. So it's important that we stick to the facts, and it's important that we don't conflate different mechanisms within the planning system. Thank you.
So to clarify, the circumstances that have been described are not matters that are subject of a voluntary planning agreement. This policy, which is, I reiterate, a draft to go on public exhibition seeking submissions, doesn't deal with that circumstance.
Indeed, and I clarified, this is not a VPA, this is a VPA policy. The operative word there is policy. It takes months and months, if not years, of negotiations to enter into a VPA. VPAs are very complex. As I said, the operative word here is policy. When we do come to actually negotiating VPAs, the operative word there is voluntary. Council can't be forced into a VPA. Developers or landowners can't be forced into a VPA. It is completely voluntary, and there's very established case law on that.
Thank you. Unless there's any further questions from the panel? Thank you.
Thank you.
We move on to development applications. Item 6.1 is DA 24/0673, proposal for the demolition of existing dwelling and associated structures and construction of centre-based childcare facility, brackets 96 Place, close brackets, at 22 Rosemary Crescent, Bowral. I have a number of speakers listed. Four I have on my list. First being Alan Spence. Would Alan Spence like to come forward and speak?
I did ask that I speak after Michael Brown, so we won't.
I wasn't aware of that. I'm happy for Michael Brown to speak first if that's your preference. I just have a list and you're the first one on it, unfortunately. But I'm happy to have Mr. Brown come forward.
Mr Chair, can I just say that I don't feel so well now, so I've asked Carol to do my speech.
Sorry to hear that you're unwell, Mr. Brown.
I'll answer all the questions right from the panel. Thank you.
Okay.
Just wait. Yeah, not good.
Sorry to hear that. Now, sorry, if you could just repeat your name and your interest in the matter, please. Red button?
Oh, okay. Thank you. I'm Carolyn McGregor. I live at 24 Rosemary Crescent, Bowral. I'm adjacent to the site for under development at 22 Rosemary Crescent. I'm also a member of the Rosemary Crescent Action Group who...
Sorry to interrupt, but are you the site that adjoins this site or on the other side of the laneway?
I'm on the other side of the laneway, the south
you.
side, yeah. I'm also part of the Rosemary Crescent Action Group that employed or requested that Michael Brown undertake an unbiased and professional report, a review of the application that has been made to ensure that we were not just doing not in your backyard sort of approach to knee-jerk reaction to this development. Michael agreed, he provided the report on February 2024. This does not seem to have been addressed in any of the council papers or documentation that's been prepared. And we were very pleased when he agreed to come along and speak on the behalf of the Rosemary Crescent Action Group to discuss his views of this rather major development. He asked that it be noted that there were 72 objections to the proposal when first notified and 35 for the second round of notifications. He also draws attention to the panel that the requirement to provide a contamination assessment for a special use proposal, being the child care centre, and the requirements for the resilience and hazards SEPS, which requires a minimum of a preliminary site inspection. Subject to the outcomes of the investigation, a detailed site investigation must be undertaken, and there can be no reliance on the site being signed off in 1999. What has happened in the 25 years since? The council report essentially relies on the fact that the land has been used for residential purposes and therefore does not require preliminary site investigation. This may well be fine for another dwelling to be constructed, but this is a childcare centre for 96 children. A PSI, in my opinion, cannot be ignored by council because of the zone. If the application was a senior housing development, would the council have the same opinion? He also draws your attention to the childcare centre SEP. The SEP requires a contamination assessment to be undertaken as required by section 3.23 of the matter for consideration and regulation 25. the requirements of the SEP have been ignored. In any matter before the Land and Environment Court, the court does not have the authority to approve an application whereby a contamination assessment has not been submitted and provide a statement that the land is suitable for the proposed use. In this case, a special use. This is a jurisdictional requirement that the court must be satisfied that the land is not contaminated. The panel sits in the shoes of the council in making a decision to approve or refuse the application, no different to a court. In my opinion, this panel does not have the authority to approve this application as a jurisdictional requirement under section 4.15 of the Act. Requires an assessment of environmental impacts which are covered by 2 SEPs. Another point is evacuation. He notes that the front of the property is flood affected, figure 13 of the agenda. The report states that the property is in a low to medium flood risk precinct. The SEP and Regulation 97 and 168 require an emergency evacuation plan to be submitted. I have not seen such a report. He refers specifically to the following which form part of his report. The proposal does not comply with the planning principles in Project Ventures and Prittwater Council and is otherwise not in harmony with the surrounding buildings. Okay. Mm-hmm. So, yeah, sorry, yeah. Read for me to read. No, that's fine. I think I'll leave it there, and if you have any questions, Michael will be happy to answer them. He's well enough to help you in that regard.
Pardon. Are there any questions from the panel to this speaker or to Michael Brown? Panel? Okay, thanks very much.
I should mention that I'm also down to speak. Can I have my own?
Okay, you're Carolyn McGregor.
Carolyn McGregor, yes.
So, who wants to speak next? Carolyn or Alan Spence?
Alan will speak next, yeah.
So my name's Alan Spence, and I live directly opposite there where you were this morning, and thanks very much for going along there. I appreciate it. Yes, 21 Rosemary Grade, directly opposite the thing. I have an engineering business. It's been going 44 years. I'm a mechanical engineer. I served on the Economic Development Committee for the council here. I represented the council here for a couple of years at rural conferences. One of the things that hasn't been brought up is that the road is only 7 metres and 60 centimetres wide, not 8 metres, which has been all along what this was based on. The other thing I'd just like to bring up there too is that it's said that to drop the child off and go up, go through the security gates, sign in, see the person who's you taking the thing, and then go back all the security gates, go back to the car, get in the car, and I've asked a lot of people, and my son's got kids, it takes at least 10 minutes, minimum 10 minutes. So yeah, our biggest worry is getting out of our car park. I'm lucky in that I go to work at 5:30 in the morning, but I'll be hit with the same thing when I come home from work. And this ludicrous statement of telling people that you've got to go in a clockwise direction. I can't see how they can do it. They'll have to get the Roads and Traffic Authority to make it one way. Look, there's 3 childcare centres in a radius of 2 kilometres. 2 of those have vacancies for next year. in our area, there's one household that would use this. You can see the people here, we don't have kids. The 100 submissions, the council has never had 100 submissions to something like this. So it just shows you the number of things that we're so worried about. You are the experts. Our way of trying to get this done is we got the expert in Michael Brown to give the report. Now that report outlined where the report by Greenway, where there was facts that were wrong. And it hasn't been anything in... Now, there are obviously serious safety issues, and this is what we're worried about. If there is an accident, God forbid if it's a fatal accident, the courts will come to who has passed this off. And unfortunately, you're part of this. And I hope that you give it the yellow flag, the yellow light, not the green one, and go back to council and say, hold on, there's some facts that have been brought up here. Now, just so as you know, in Queensland, a 3-year-old child was run over in it wasn't McDonald's, but it was one of these other ones, and it went back. It went back. Who did this? Who okayed it?
Can you summarise your issues?
No, I'm fine now.
Stick to the facts that relate to this case, and
Well-
just tell us why.
Well, the fact is that we are all concerned that the things that they're putting forward, this ridiculous statement about going counterclockwise, going in a clockwise direction. Someone new to the area, hold on, what's going on here? All these cars are coming this way, there's no one way or anything on it. Look, we're here. There's never been so many. But all right, I'm finishing up, and thank you for your time, and I'd like to thank you for coming along this morning and having a look.
Thanks for your contribution. Don't go away just yet. I'm going to ask the panel if they have any questions or comments to make to you. Panel.
Just want to reiterate, we have been to the site and we have read all the submissions. There are a lot of submissions, so we're very much appraised with what the issues that have been raised.
Oh, I thank you for doing that.
Thanks very much.
No, thank you. And thank you for going along this morning.
I think that's all the speakers. Unless, oh, you want to get you, Carolyn, second go, as so to speak. And there's another one. Who's that? Oh, sorry. I beg your pardon. Okay. So who's next, Mr. Ison or Ms. McGregor?
Good afternoon, Mr. Chair, and thank you for to the planning panel for allowing me the opportunity to speak. My name is Wayne Ison. I live at 47 Alice Avenue at East Bowral, which is on the corner of Rosemary Crescent and Alice Avenue, which is about 150 metres from the proposal for the construction of the centre-based 96-person childcare facility. I don't want to bore everyone, but just reiterating what's been said before, and I appreciate that the panel have noted probably what I'm going to say, but I'll be very brief. After reviewing the drawings in terms of height, bulk and scale of the proposed development, the appearance with the existing buildings which surround the development, I believe them to be completely out of character and harmony with the street. The proposed facility, in my opinion, is an overdevelopment of the site and will be visually prominent when viewed from the surrounding properties. In terms of traffic generated by the facility, Rosemary Crescent, as was said before, is a carriageway of a touch over 7 metres wide, not 8 metres, as was incorrectly noted in the headway traffic report, with vehicles parking on the street and various heavy vehicles, for example, school buses, rubbish removal trucks and delivery vehicles as well, coming and going. I believe the opportunity for significant dangerous impact on those people who are using the facilities and those of us who are involved in the street is obvious and must be taken into account. This leads to, once again, the total unsuitability of the site for the development of a childcare facility of this scale. Further point, the Ringakarabie Local Environmental Plan 2010, Section 13.5 states, and I'm going to read this out very briefly, in order to minimise the possible adverse health effects of children of electromagnetic radiation emitted from telecommunication facilities, childcare centres should be no closer than 300 metres to existing mobile phone towers or antennas or transmission line easements or other similar electromagnetic radiation sources. The proposed site at 22 Rosemary Crescent is in fact approximately 250 metres to the high tension transmission wires located above the easement in line with Alice Avenue, running north-south towards the Ponds of Reflection. Now, you may not be aware of the Ponds of Reflection. The Ponds of Reflection are in the parkland near the Botanic Gardens. This is clearly in breach of the relevant section of the WLEP 2010. So just concluding, the proposed development of a childcare facility, and I repeat, of this scale, is not suited to the location and should not be approved to take place. Thank you very much for
Thanks
hearing.
very much. Just wait a moment to see if there's any questions for
Thank
you
you.
or comments. Any further questions from the panel? Thank you very much.
Thank you very much. Thanks for your time.
Now we have Carolyn McGregor, the final speaker. Just look, we will take them, but we will give them what weight is appropriate for them having been received just now. Okay, it's not our policy to receive documents on the run, but we'll see what we can do.
Will I introduce myself again?
Yeah. I've just been asked a question by a panel member about the neighbour to the northeast at number 23.
Number 20?
Is it 20? Number 20, I beg your pardon. Yes, number 20.
They're here today.
Are they here?
Yes.
Who is that?
Ari and Anthea, they're not speaking today because their first language is Greek, and they don't
Generally,
feel
what's
confident.
their position on the matter?
They're definitely against it.
Okay.
Definitely.
Do we have okay, no, I think that's enough. Yeah.
Will I introduce myself again?
Yes, introduce yourself again for the record, please.
Yes, my name's Carolyn McGregor. I'm from 24 Rosemary Crescent, Bowral, which is adjacent to the development. We will be dramatically affected by this huge commercial development. It is not just a childcare centre, it is a large commercial operation incompatible with the surrounding residential area. It will be the largest childcare centre in the Ringakarabie Shire, and it is only matched in size by centres operating in metropolitan areas such as Campbelltown. Photographs provided are misleading, particularly the photos showing the centre nestled in the existing greenery and trees, all of which will be cleared and cannot be replaced due to the extensive coverage of concrete on the site. The landscape report even refers to trees being affected on the adjoining property at number 20. There is a stark difference in the development's footprint to surrounding neighbours. It is evident from the DA site analysis plan that the rear setback for this development is radically different to any other surrounding property, as is the scale. It is not compliant with Bowral DCP, which states rear setbacks of a new development will be generally consistent with those of existing adjacent development. In fact, to me, it is, in looking for a comparable building site, the only one I could find was the Mittagong Health Centre. If that, as it is the case, is built, it will block our view, destroy our visual and acoustic privacy, and overshadow our home, blocking access to sunlight in our main living areas and negatively affecting the operation of our solar panels. The New South Wales Child Planning Guidelines state that we should ensure that childcare facilities are compatible with the existing streetscape, context and neighbouring land uses, and minimise any adverse impacts of development on adjoining properties and neighbourhood. This development is non-compliant. Alan and Wayne have both talked about the traffic pedestrian conflict, which is alarming, and it poses a major safety risk to vehicles, pedestrians and children. Wayne has also mentioned the electricity transmission lines, which are a health issue, particularly for the safety of the children using this site. And finally, the Barrel Development Control Plan requires a statement clearly indicating the proposed number of children, their ages and staff numbers. It creates grave concerns for the quality of childcare provision when conflicting statements regarding staffing are very fluid in order to comply with parking requirements. In the traffic report, they state there are 8. In the recent materials, it states there's 5 permanent staff, and in my looking at what they actually will be, they will be at least 17 plus staff to be compliant with licensing regulations. These are only just a few of the issues and details that have been raised in previous submissions, and I'm so pleased to hear that the panel has gone through them all or going through them all. We feel that we haven't been well heard until today, and I certainly appreciate the opportunity to come and speak to the panel. Thank you.
Don't go away just yet. Are there any questions or comments from the panel? I have a question. You mentioned view loss.
Yes.
What? Can you explain that? I don't understand that.
Sorry, at the north side of it, we have a wraparound veranda. The north side of our building faces across gardens, across East Barrel, up across to the hills that surround.
So you're looking across the side boundary, though?
Sorry?
You're looking across this side?
Side boundary. At the moment, all we see is slightly the top of the tiled roof of the building, but in future we'll be looking at the site of a constructed building, a blank wall
so
with
it's a
some
sort of regional
narrow
view.
windows in it.
It's a sort of regional view loss.
Yes, oh, definitely, yes. It's a beautiful place to sit in the daytime. The view, the sunlight, it's an incredibly lovely area at the moment.
And can I ask you, on what basis do you say that you'll have loss of solar access?
The shadow diagrams illustrate that slightly. I don't know that they're sufficiently accurate, but if there is a wall there, there's no way that our living area will receive any light, and I doubt that our solar panels will receive the light, which sort of are at the back of the house but angle to the north side.
Just one question, thank you.
Yes.
So that I've got my bearings. Your house is the beautiful one with the balcony that's quite elevated
That's correct, yes.
to the left of the public pathway when you're standing on the street.
When you're left, yes.
Okay, thank you.
Yes.
So it is quite high in that
Yes.
sense, yeah. Okay, thank you.
Thank you. Okay, thank you.
Thank you. Sorry, I didn't have the microphone on then. So, we move to item 6.2, which is DA 2022/1747, the construction of a retail/commercial building at 51 Renwick Drive, Renwick. Against the recommendation, I have to speak Jane Fusi. Fusi? I hope I got your name right. Could you give us your name and address, please?
Yeah, Jane Fuzzy, Dilleret Street, Renwick. Thanks. Ladies and gentlemen, distinguished guests, I'm one of the earliest residents of this estate. Thank you for coming out this morning and having a look at the site. I'm before you today to advocate for the Renwick community about a cause that is close to our hearts, which is the preservation of the original vision and design for Renwick. As concerned residents, we believe that the essence of community lies in shared spaces that bring us together and inspire us and foster a sense of belonging. We support the development at this address. However, the current proposal for the commercial building in Renwick deviates significantly from the original plans that were presented to us by Landcom. The promise of a cohesive and welcoming environment designed to complement the local architecture has been overshadowed by a design that lacks harmony with its surroundings and fails to capture the essence of our community. We bought into this vision. We invested in this community with the expectation that the spaces we gather in would reflect our values, our heritage and our aspirations. We envisioned a place where families could come together, children could play freely in a safe, inviting environment, and where neighbours could connect and form lasting bonds. As residents of Renwick, we seek development outcomes that align with those outlined in the Mittagong Town Plan DCP, a vibrant and inclusive community. We envision a community building that respects the original designs and plans. We call for a return to the original vision that was promised to us, ensuring that this community building reflects the architectural style and aesthetic that resonates with our local identity. Promotes community cohesion. We desire a space that fosters connections and encourages interaction among residents, creating a welcoming environment where people from all walks of life feel valued and included. Supports community activities. We advocate for a versatile community space that accommodates a range of activities and integrates seamlessly with the surroundings. We emphasise the importance of a design that harmonises with the natural landscape and existing infrastructure, enhancing the beauty and functionality of our community. It should uphold transparency and accountability. We call for open communication and collaboration between stakeholders, ensuring that the development process is inclusive, participatory and responsive to the needs and preferences of the community. We have some concerns with safety with this building from an access perspective and also the lack of setback from the road. It's incredibly imposing, and every other building and house in Renwick has been built with setback from the road to enhance garden and green space. So I say let's not settle for mediocrity. Let's strive for excellence. Let's create a community building that stands as a beacon of unity, a testament to our shared identity and our collective vision for the future of Renwick. As per the Landcom website, this distinctive development has been thoughtfully designed to capture the essence of the Southern Highlands and the essentials of modern living. It's a place that harmonises nature and landscape. The New South Wales Government architect Abby Golvan recently said there was no specific rules that govern artists' impressions, but designers and council planners could object to an artist's impression if it's not accurate when compared to other drawings for a project. The current proposal is a completely different style and aesthetic to not just the original images, but also to no other buildings in our estate. I ask you to consider the words of our government architect and listen to our community. We have created an e-petition through the New South Wales Parliament, and we have 161 signatures in 3 days, and we have the support of local member Judy Hannon. Surely this shows that beyond the 23 submissions that were received in the original process, our community wants more than what is currently proposed. Thank you.
Thank you very much. Are there any questions or comments from the panel for this speaker? Yes?
Thank you. Do you mind elaborating on the safety issues?
Yeah.
While you were speaking, I was canvassing the plans, and the only one that I can pick up as a potential safety hazard is the alcove around the existing sewer manhole.
Yes, so we're more concerned with the access in and out of the car park. We feel that having dual direction in both on Renwick Drive and Whitfield Lane is problematic. To come out of that car park and turn right onto Renwick Drive, you've got a bend coming around, and then you've got a crossing that's been developed in front of the community centre. Also with trucks accessing Whitfield Lane as well, it's quite a narrow space, and there's the kindergarten childcare centre there as well. So we just feel that access through in and out of the car park maybe isn't ideal.
Thank you. Yes, I did see that childcare centre. The road is quite narrow there. Are they all the safety issues that you have for the moment? Yeah.
I think, yeah.
Okay, thank you.
Thank you.
You made reference a couple of times to the original vision.
Yeah.
On the one hand, we're here to determine an application whether it's reasonable, but I'm interested to know what is it about this original vision that's changed so much that you now find this proposal
Did you receive the
objectionable? I haven't seen the original
document I
vision.
sent in? It's got the original design concept.
I don't think I have.
We've got, we've had,
Have you seen the original vision?
it's going from French Boulevard to Airport Terminal, essentially, is what our feel is.
Okay, well, I'm asking for this, so I suppose I should accept it accordingly. Thank you. So, the elevations look very similar to what's now proposed. You know, these ones are very similar to what's now proposed.
Yeah, it's not so much about the two-storey, it's about the style that doesn't fit into the Renwick community
Not
surrounds.
looking like that. Is that
It doesn't have any aspect of heritage, connection to community
I'm not sure what that
area.
what part of the design that original concept sketch reflects, actually. Anyway, thank you.
Thanks.
I don't think there's anything further from the panel. Do you want?
Michael Levin. I'm a 10-year resident of Renwick, 42 Dilleret Street, Renwick. I'm going to confuse the issue just a little because whilst I ticked the in favour of box, it's very conditional because there isn't an alternate to for and against, and I did want to get some comments on the record. The earliest schematics and the earliest plans, drawings, etc. for Renwick refer to Renwick as Renwick Village. I think you may have seen that if you've gone back to the early drawings and plans and definitions and so on and so on. It's quite clear in there that Landcom had a view that this had to be or could be a village by nature, notwithstanding 650 homes or thereabouts. When this proposal first came about, the objections from the community and individuals were quite strident. It looked like something that should have been in Crow's Nest or Chatswood, and certainly not in Renwick, and certainly not in a village atmosphere. The current report to the Planning Council, to the Planning Panel, says the village centre is to accommodate basic shopping, cultural and recreational social facilities, offer maximum convenience and comfort, and must be an attractive destination with a unique sense of place for locals and visitors alike. Now, this very much echoes what the previous speaker has said or spoken about in terms of that sense of place and community and so on and so on. The revised plans have taken some of that into account with the pitched roof and the galvanised materials and so on and so on, but at the end of the day, it doesn't go far enough when you look at it in terms of what the original intent was for a village atmosphere. And as I said at the beginning, that there wasn't an appropriate box to tick. I'm in favour of a development on this site because we've waited for 10 or 12 years, and some residents have waited for almost 15 years for this to come about. And my concerns are, as an individual resident of Renwick, that if something doesn't happen very soon, it won't happen. We waited quite a number of years for the community centre to be built. It's a very fine addition to Renwick, and it's well utilised now. It does fit in that sense of place, and whatever goes on this commercial site has to be harmonious. And it may be that there's some further adjustments can be made to this plan that makes for that harmony that the community is looking for and individuals like myself are looking for, as opposed to a building that could be in any other setting and be totally nondescript. So my call to the panel is to really have a look at the design, see if it fits within that sense of place and village atmosphere that was intended for Renwick, and see what can be done to create something that the community is proud of and that fits neatly into the atmosphere that has been tried to be created by both the resident and certainly Landcom and the council over time.
Thank you.
That's my statement.
Thank you. If you just hold your seat for a minute there, just wait a minute. Just wait a minute. I'll ask the panel if they have any questions for you, and then, any questions? Sorry. There are no questions, so thanks very much. Okay. That being the last item on the agenda, I'd like to thank everyone for attending today, and especially those who spoke and expressed their opinions. The panel will move into closed session to deliberate, and will announce its advice in public, which will be webcast following the deliberations. The minutes should be posted on the website by close of business Tuesday. So that being the case, I'd like to thank my fellow panel members and council staff for their assistance today, and I declare the meeting closed at 12 minutes past